Bonjour et bienvenue à tous et à toutes. Nous restons très heureuses de vous accueillir ici aujourd'hui. Et nous croyons que cette question des droits humains dans le domaine des ressources naturelles et le développement durable est vraiment une question d'importance centrale dans la société canadienne.
We'd like to, take that. This is for the video purposes. We'd like to, first of all, thank the sponsors of this event, the Social Sciences and Humanities Research Council, the Human Rights Research and Education Center, the University of Ottawa, the Faculty of Law Common Law Section, the IUCN Academy of Environmental Law, and the Environmental Law Group, who have given us the funds to make this happen. We'd also like to thank at this point the people who did the major part of the organization, Jordana Laporte and Andrew Brown, who have both been instrumental in getting this organized. Most of you have probably met Jordana in the course of correspondence. And we also have some rapporteurs who will be sitting in the room. Not all of them are here yet. They'll be taking shifts. Some students who are going to be working very hard. Stanko Kristik, Susanna Kam, Samantha Montroy, Julian Daller, Roxanne Gunning, John Anen, and Alina Apostol. So we'd like to thank them for volunteering their time to come and help us out with this event. And also, now I'd like to thank everybody for coming, especially for those people who came from a long way away. I know that, well, we've got Huya, Woods, and Brad Morse, who've both flown in from New Zealand. And I know that Huya had to take at least 4 flights to get here, so, and is completely on the wrong time. So thank you very much for making the big voyage. We have Natasha Affolter coming from Vancouver, and she'll be joining us later. And thank you, Maureen Whitney, coming all the way from Toronto, and Joe Castrilli as well. For I can't remember where you came from this time, but you were Toronto as well. Okay, and everybody else who's come here today. What sparked our interest in this issue was the focus of the dialogue that's been going on in Canada about the extractive industry and how it's operating in developing countries, the human rights and environmental impacts. And the reports that were coming out of the Standing Committee on Foreign Affairs and International Trade, and then the ensuing roundtables on corporate social responsibility and the extractive sector in developing countries, and then the following advisory report that went to the government, a 2-year lag, and then the government's final response in March of last year. This dialogue has focused on the policy imperative that Canadian corporations abroad should comply with the same standards that they comply with when they're at home. And so the implication is that the standards in Canada are high and that Canada is compliant with its international human rights obligations in its own extractive industry that goes on domestically. But there's been comparatively little focus or little public dialogue on what those standards are and the extent to which human rights writ large are protected in the context of mining activity in Canada. And Canada itself is host to the highest some of the highest mineral exploration activity in the world, and Ontario produces 1/3 of Canada's mineral output. So we wanted to explore this question of whether Canada was complying with its international human rights obligations in its own domestic mining sector. And here, when we're talking about human rights, we're talking about human rights writ large. So Indigenous peoples' rights, environmental human rights, economic, social, and cultural rights, civil and political rights, etc. So at this point, then I'll pass the microphone back to Linda. This is rather awkward.
So the focus of today is really a collaborative gathering of academic experts and people with expertise from the real world. And we really encourage you to engage in an open dialogue today. You know, one of the nice things about a closed-door meeting is we can feel absolutely free in sharing whatever we really think about these things. So the goal then is to hear from everyone briefly, but really we're here to talk to each other. And so you'll note that there are breakout sessions in both the morning and the afternoon. And because we definitely want to protect that time, we will be rather strict with the 10-minute speaking limit. So you will notice one of us waving wildly from the back and or passing notes if you're heading towards the end of your 10 minutes.
Yeah.
Okay, great. So let's get started with our first panel. We're going to vacate the front of the room and invite panel members to just come on up here. And because we are videotaping, if you don't mind using this little mic, that would be helpful.
Yep. Okay, I'm just going to use the computer. So hi, I'm Maureen Whitney, and I'm the research director at the Canadian Institute for Environmental Law and Oh yeah, the microphone. Sorry. And my presentation is on the recent amendments, which actually have actually now happened, to Ontario's Mining Act. Just a brief overview of the presentation. I'll give you a bit of background. I'll talk about what the Mining Act looked like before 3 weeks ago, about the provincial review process, the principles needed, at least from the perspective of me and the co-author of the report and the people that we consulted with, and what actually happened in terms of legislative amendments. So this is based on a report that was published in October 2008 called Balancing Needs, Minimizing Conflict, a Proposal for a Mining Modernization Act. And it was co-authored with Justin Duncan, who's a lawyer at EcoJustice. We looked at mining regulation in other jurisdictions, but we also developed our recommendations in consultation with some NGOs such as Mining Watch, Wildlands League, Ontario Nature, some First Nations groups, and other stakeholder groups, human rights groups. Someone from Amnesty was involved as well. So we bounced off our ideas in that group. Ontario's Mining Act until late October was really still the 1906 Mining Act that had introduced the free entry system in Ontario. At that time, it was intended to encourage mining as a means of increasing settlement in frontier lands. And the free entry system, just to give you a description, and this actually comes out of the provincial government's own discussion paper on the system, was that it included the rights for prospectors to enter lands containing Crown-owned minerals, and to acquire mineral exploration rights by staking a claim, and then rights for the eventual claim holders to carry out further exploration within the claim area, and to obtain a mining lease to undertake mineral production. And once you were sort of in the door, that flowed through pretty smoothly without many roadblocks. And that system had continued under the Mining Act with only a bit of legislative tinkering, fairly minor amendments, over a century or so. The law gave preeminence to mining interests over other rights and interests and other potential land uses that are valued by the public, including the exercise of Aboriginal and treaty rights, recreation and tourism, basic ecological services such as water and air purification, species habitat, carbon sequestration. And the Act gave no opportunity for environmental assessment of the impacts of mining. And not only was there no environmental assessment included in the Mining Act, but Ontario's Environmental Assessment Act had, under that legislation, mining was exempted. So it wasn't subject to the EA regime that is, such as it is in Ontario, that is in place. So it prevented government from assessing the impacts and imposing environmentally protective and mitigation measures. Over recent years, there's been quite a bit of criticism of mining law for this placing of mining over other interests and rights and land uses. The Environmental Commissioner has been a particularly strong critic, and for those of you not from Ontario, that's an arm's length position that reviews and critiques Ontario decisions on related to the environment, as well as commenting that the old system, didn't reflect modern planning or resource management. The ECO also said that free entry impeded land use planning, assumed mineral development was appropriate almost everywhere and was always the best use of Crown land. And the ECO noted that the existing regulatory structure did not adequately assess cumulative impacts of development. Then in 2006, there was a court case, Platnex versus KI, in which the court held that the government has a duty to undertake meaningful and reasonable consultation with First Nations when granting mining claims and leases that may impact their rights, and that duty could not be abdicated or delegated to third parties. I believe Bob Lovelace is going to be here. Yes, yeah, and he'll be able to tell you a lot more about that. But that court case also, I think, put pressure on the provincial government to review the Mining Act. So in July 2008, the government announced that it was going to review the Act and make amendments. That timing worked very nicely for Justin and me, because we had found funding to do this paper in April of 2008. So it was, that worked out very nicely. And then after an initial consultation and a discussion paper on the part of the government, amendments to the Act were proposed last April in Bill 173, and it was just amended in late October. It received royal assent. So just this is kind of an overview of the principles in our paper. I don't know how I'm doing for time. I don't know if I should.
You are now at 4 minutes remaining.
4 minutes, okay, so that always happens. I'm gonna, you all have this presentation, so I'll just try to quickly, I'll highlight quickly what is left, because I always think I have lots of time, and I don't. The main areas that we focused on were land use planning prior to mining, and the thrust of what we wanted in the Act was something that would ensure that land use planning processes preceded mining activities. I mean, things happen differently in different parts of the province, so we dealt with that. The paper also did suggest specific legislative language for amendments, and I'm not going into that because that's pretty dry. Environmental assessment was another focus of the paper. So we strongly advocated environmental assessment in different forms at every stage of the mining cycle, starting with staking and going on to different levels of exploration and actual mining. We also, it's not on the slide, but we also, at the later stages of environmental assessment, recommended participant funding for meaningful participation in the process. We recommended a requirement for Aboriginal people's free, prior, and informed consent. Other jurisdictions do allow veto rights to First Nations when mining occurs in their territory, and we felt that that was a precedent that should be followed in Ontario. And certainly there's a constitutional right for First Nations for consultation and accommodation, and that was not represented in the old Mining Act, and we argue actually hasn't been in the new one. So. Increased regulatory oversight, a permitting process, because right now once you had staked your claim, there really weren't any permitting requirements, and you could just kind of breeze through, and there actually wasn't a lot of ministerial discretion to stop you at any stage. So we also wanted discretion from the minister to refuse permits and cancel mining claims where people weren't acting properly. 1 minute, okay. Surface rights, I won't get into this, it's on the slide, but that was a very contentious issue too, that some people owned the surface rights and the Crown owned the rights to mining beneath. Increased transparency, public notice, and opportunities to participate were lacking, so we felt that should be included, and financial security, stronger financial security for cleanup and reclamation. There are a lot of abandoned mines in Ontario, and a self-funded regulatory scheme. So what we actually got once the amendments came through, a slight improvement in prioritizing land use in the far north, not so much in other parts of the province, so that is still a gap. We still need stronger powers for land use planning in the north and southern Ontario, the near north, sorry, and southern Ontario. There were no environmental assessment requirements introduced, and the exemption has, for a while anyway, been continued under the EA Act. However, we've been told that the regulations, there are quite a few regulations that need to be developed now that the Act is through, and we are told by ministry staff that EA will be part of that. Well, the purpose section of the Act does talk about recognizing and affirming existing Aboriginal and treaty rights. There's no reference to the duty to accommodate. There is now a dispute resolution process in the Act for Aboriginal communities. We did get some permitting, so that was a bit of a victory. There is now going to be an exploration plan required for certain activities, an exploration permit for other activities. Again, left to the regulations, so we're not sure how that's going to look. And they've dealt with the surface rights problem by withdrawing those lands where there's a surface rights owner and the Crown owns the mining rights. They've withdrawn those from mining activities in Southern Ontario. And that is my speeded up version, sorry. Thanks.
Okay, so I'm going to try to be really efficient here. As I said, I'd like to mention that the report that was prepared by EcoJustice in partnership with a Quebec coalition called Pour que la Québec ait bonne mine is something that was done with a whole bunch of help from the students at the University of Ottawa EcoJustice Environmental Law Clinic. So this is a partnership arrangement that's been successful for the last 2.5 years, and I'm not sure how I get rid of this view. Slide.
Oh, slideshow.
Slideshow.
All the way over. No, go over.
Aha. Okay. So effectively what I'm saying is a whole bunch of students' work went into this report, which is fabulous. And so we're very happy that we've got this collaborative venture with the university. It's producing results. And although I won't be presenting in French today, I've prepared my slides in French. And the report is available in both languages. In fact, it was written in French and recently translated into English. I actually prefer the French version. It's a bit more precise. There's my quick introduction. By way of, I mean, a lot of what is recommended in our report vis-a-vis the Quebec Mining Act is similar to what was recommended in the CLAP and EcoJustice report that Maureen has just spoken about. But the context in which this debate is situated in Quebec is slightly different, and I think it's interesting to note that there hasn't been the same tenor of debate between Aboriginal peoples and the Quebec state the way there has been recently in Ontario. There haven't been jailed leaders. There haven't been demonstrations. It just hasn't been the same. What is different is that there was in April 2009 an Auditor General's report which lambasted the Quebec government for not only for not enforcing their own regulations, but for not ensuring that that guarantees for mining site restoration, financial guarantees in case they walked away, there was no follow-up on that. And effectively, what they found is that the rents received by the government in the form of royalties are being dwarfed by the environmental externalities that have been bestowed upon the Quebec taxpayer to the tune of $300 million. So this is becoming this issue is being framed less by confrontation with First Nations and more through this sort of the prism of the taxpayer value, and that raises the same issues of a lack of environmental assessments. Raises all of these same issues, but in a totally different light. So people are starting to say, well, if you're not going to do an environmental assessment, what's going to come down at the end of the pipe? What am I going to pay? So, anyways, just to sort of set the stage in that context. Let's see. So the first issue. Now I'm going to frame. I've got 5 slides. I'm going to try and be really quick. If you could just show me the hand on the number of minutes, that'd be great. 5 minutes left. Wow. Wow. Did the time start when I just started moving my chair? Anyways, okay. So
We have a bit more time in this panel because
I'll stick to my 5 minutes. I'm okay. The report prioritizes recommendations under 5 broad headings. The first relates more generally to democracy, and this speaks to the time-worn critiques of adequate information provision to landowners, to municipalities, and obviously to First Nations as to what's happening with mineral exploration. It also goes to those same issues of consultation, prior information, and consent in terms of mining projects. So, in addition to our recommendations to transform the actual purpose of the law, and I'd be very interested to find out if Ontario's purpose has actually changed to include environmental sustainability goals. In Quebec, there is nothing of the sort, and the Mining Act, as it's currently formulated, doesn't give a nod to any of the core texts of Quebec law as relate to sustainable development. In particular, the Sustainable Development Act, which came out a couple of years ago, and is replete with principles that have to be applied by the government now in the implementation of all of their duties. So. Definitely, the time is ripe for a revamping of this statute. And I should have said before, I was remiss in not mentioning, I'm moving too quickly. The Quebec government, in all of this, in its own special context, has been looking over its shoulder at Ontario and saying, "Oh, they saw the KI decision, which they assume would be the way the courts in Quebec will apply things, and they know that amendments have to occur. They went through a whole consultation process to develop a new mineral strategy, and at the end of that pipe, when they delivered the strategy, they said, we're going to recommend legislative changes. So we're anticipating in the next week or so that a new law will be proposed, or amendments to the law will be proposed. How extensive those changes will be are anyone's guess. We do know some of the proposed changes will relate to environmental assessment, and I'll get to that in just a moment. What we don't know, though, going back to this purpose of the law, we don't know, and we are strongly recommending that the purpose of the law not only be to favor the expansion and exploitation of mineral production in Quebec. So similar critique about environmental assessment. You don't need to do an environmental assessment on a mine in Quebec unless you're producing 7,000 tons per day. That comes to 2.5 million tons a year. Those are huge, huge mines. And since 1994, there's been one mine, which is a giant iron mine at Bloom Lake. It's the only mine that's gone through a comprehensive environmental assessment process in Quebec. So that gives you a sense of the problems. For any type of mineral exploration, for any type of mineral exploration, no environmental assessment is required. The third, sorry, I didn't even shift it on my computer. I didn't shift for everyone else. I'll leave this up for a moment. The third area where we have made recommendations relates to land use planning, and this speaks specifically to the role of municipalities in mineral development, in mining development in Quebec. Right now, municipalities and regional county municipalities have no say. They have a voice, but they have no say. That's obviously problematic. So we're certainly hoping that there's a greater role and a greater emphasis on the principle of subsidiarity in this process. We're not that hopeful, but we're recommending it. Oh, I'm sorry. I thought my booming voice might just get one on the table there. Okay. One of the key principles in the Sustainable Development Act is the polluter pays principle, which has obviously been dealt with favorably by the Supreme Court of Canada. We are hoping that this principle is incorporated directly into the Act, and this will, I anticipate this is something that the Quebec government might look to do, if only to address the Auditor General's critique, because right now the public perception is the polluter is not paying at all. another sort of key detail, which, I mean, there's so many shocking details when it comes to analyzing the Mining Act, but in the development or in working towards Quebec's goal of achieving 12% protected areas, it's been taken as a given by the government that no areas where there is a mining claim or areas where there was previously a mining claim, where there's mineral potential, none of those areas are open for protection. So as long as there's a claim there, it's done and over. There's no protection, which is just backwards as far as we're concerned. And right now, Quebec law, which was amended in 1995 to provide for a 70% restoration guarantee, it's obviously not sufficient. The demands, the request is that it be bumped up to 100%. We're anticipating that the Quebec government is going to move in that direction. Finally, and this slide goes to the reason why Eco-Justice, at least in the Ottawa office, got involved in this issue. Uranium exploration has really touched a nerve in Western Quebec and Eastern Ontario. We're going to hear a lot more about that later today. But we actually got involved in this not so much for environmental reasons, but because private landowners were saying, "What the heck are you doing on my land? This is outrageous." And so we thought, well, heck, yeah, this is outrageous. Let's figure out a way to assist. A number of municipalities in the province of Quebec, a number of First Nations groups, and a number of civil society groups, of course, have called for a moratorium on exploration and exploitation of uranium mining. We don't anticipate we're going to get very far with this, but certainly the pressure is mounting, and I guess I'll conclude there. Thank you.
From Natural Resources Canada, who's the lead on the social license to operate.
So, right. So, given the experience of my predecessors, I'm going to talk as fast as I possibly can. Yeah. All right. Yeah, really. Okay. All right. So to start, merci de m'avoir invité ce matin. It's a pleasure to be here and learn from everybody around the table. I'm a senior policy advisor with the Minerals and Metals sector at Natural Resources Canada, so the federal natural resources section. I'm going to have a very different type of presentation this morning. The focus, I think, my presentation is really going to focus on some of the potential opportunities to address the deficiencies that have been raised in the other presentations through some of the intergovernmental institutions and spaces that exist. So I'm going to just do a quick check around the room. I'll take 20 seconds of my time to do this. How many people here have actually heard of the phrase Mines Ministers Conference? Okay, so that's good, about half. How many people have been to a Mines Ministers Conference or had their organization attend a Mines Ministers Conference? Okay, so one. Mining Watch. So that's going to be a theme I'm going to come back to again and again, which is the importance of engaging diverse stakeholders in these intergovernmental spaces to create an opportunity to identify and then collaboratively problem solve some of these challenges. So I'm going to start off at the micro level by looking at a specific project, a mining sector performance review project that's being run by a social license task group. And there we go. So before we get into the details of the project and the group, I just want to map out the landscape a little bit. So on the right-hand side, you can see this, the Social License Task Group, which is a committee of assistant deputy ministers from jurisdictions across Canada. So Quebec, Nova Scotia, Saskatchewan, Newfoundland and Labrador, and the federal department. And we're one of several working groups that exist that are joint federal, provincial, territorial working groups that exist to problem solve challenges that have been identified by others and by ourselves and by ministers, and to, in essence, optimize the mining regime in Canada, which is the focus of this panel. So if you move to the left, these subcommittees all report to something called IGWIG, which is the highest level of civil servants meeting that meet regularly on a regular basis to address some of these issues. And that group in turn reports to ministers, so elected officials, who meet once a year along with their energy counterparts at an annual conference in September. So this is kind of the intergovernmental space that I've been working in for the last year and a half or so. And it's got a lot of interesting characteristics that I think need to change if we're going to collectively solve some of the problems. So there's some strengths and there's some weaknesses, but we'll get to that as we go. So just to give you a sense of the breadth of the issues that are covered in this intergovernmental space, over the last 7 years, I just went back through all of the action plans that come out at the end of this conference where the elected officials meet, and they sort of identify their top priorities for the year ahead. And I tried to map them against the sustainable development pillars, and what you find is quite striking that most of the action plan items, so funding for geoscience, Aboriginal participation in mining, the diamond industry in the north, they tend to be framed now in a discursive way, not necessarily in an operationalized way, but discursively they're framed as to support both social and economic goals, so jobs as well as growth. And that tends to be the dominant type of action item that mines ministers address. There's also a series of other items that deal with environmental, pure competitiveness things and areas of overlap. So innovation, science and technology. The regulatory system in Canada is often addressed. Now, it's framed as being about efficiency and effectiveness, so I put it into the middle one, but in practice it's about efficiency, and that means speeding up the process. And so the challenge, of course, is how do you speed something like that up while also maintaining its effectiveness as a protective mechanism. So that's just a little bit of a snapshot of what is talked about. This is an example of something that came out of mines ministers, and intriguingly enough, it emerged because of stakeholder pressure. So Mining Watch and then industry pressured elected officials to deal with this issue. And I know Joseph is going to talk a little bit about that later. But the strengths and weaknesses of how well NOAMI works, the National Orphan and Abandoned Mines Initiative, is another discussion. But it just gives you a sense of how when stakeholders come together into this space, they can start to generate at least some kind of action. So my specific project then emerged in September 2008. And ministers at the end of their conference were having a conversation about the public image of mining. And so they were asking themselves, what does the public think about mining? Why do they keep asking for bans on uranium mining? Uranium mining is okay. I'm not going to get into debate about whether it is or not, but they said, let's talk about this a little bit more. And we want to talk about what the public thinks, how it affects the willingness of a community to grant the industry a social license to operate, and then thus its competitiveness and its ability to improve the quality of life of Canadians and generate jobs and so on. So they tried to kind of map out those linkages, but they asked us to look at that. And so this task group was set up, and we did a whole bunch of work culminating in April 2009. And the general results of the public opinion research were quite interesting. And in essence, both qualitative and quantitative data suggested that as a whole, Canadians are generally supportive of mining. They recognize that it creates jobs and wealth, but they still have very serious concerns about its social and environmental impacts. And the origins of those concerns were something that we probed a little bit. And we looked at other industries as well, so the chemical industry, the wind industry, other industries where people had concerns. And there's essentially three types of origins of concerns. And so one is certainly inadequate or inaccurate information. Sometimes people just don't quite understand something, and that is a source of concern. Sometimes it's a legacy issue. So they saw something 20 years ago, or they heard about something, and they think it's still a problem today. And sometimes it is, and sometimes it isn't. But they don't necessarily know, but they have this image. And then the third, of course, is there's actually real concerns, real problems that have to be solved. So the reason we took the time to map those out and share that with ministers was because there was a tendency for the framing of this project to be about public education and public relations. Convince the public that everything's fine, and then you'll get the social license to operate. And there wasn't as much of an emphasis on fixing the things that are wrong that are causing people to be concerned. So what we ended up presenting to ministers, and the final report was emailed, I think, to participants in English and French, was that to address public concerns, you need to have these three elements. Not very surprising, but honestly, sometimes you have to start with things that you take for granted have to be articulated explicitly. So yes, you need to improve your performance, and you do need to do communications, but what you have to communicate is that you've improved performance. not that there's nothing to be concerned about. And all those things have to be done in a credible way, which means you have to do it with multiple stakeholders, because if it's industry and government doing it together alone, no one's going to believe you. So these were some of the things we tried to share. And so they said, okay, well, that's interesting, but let's look at this again. So now, in September 2009, we got another mandate. This mandate was specifically to look at what actually has improved then in the last 10 years. So where can we say there's been regulatory changes that have had improved outcomes, there have been voluntary actions, there's been science and technology. So let's actually identify those. And those stories will be placed into the public domain for dialogue. But that wasn't all they wanted to ask. They also said, and this was a nice surprise, what has improved and why has it improved? Yes, but also what needs to improve going forward. So there are some success stories in the past, but there's also lots of things that need to be addressed in the future. And so they want us to actually identify those. So we have a mandate to actually take some of the critiques and criticisms of the mining regimes in Canada and put them onto the table. Now, why is this important for this group? Well, for the first reason is that we've tried to take this project, this mining sector performance review project, and adopt the principles that we just reported on. So we have a multi-stakeholder advisory committee that's looking at these issues with us. Mining Watch and the Centre for Long-Term Environmental Action in Newfoundland is on the committee. And we specifically went to the Canadian Environmental Network and asked them to select the delegates, because we didn't want to cherry pick whichever NGOs would just be our friends. So we're trying to model the principles that we've asked for. We've hired graduate students to work with us, and we're going to set up a virtual collaborative space on an external site where all the research that we're doing and all the questions that we're asking and all the conclusions that we're coming to are going to be posted for debate and dialogue by people like yourselves and other interested folks around Canada. So the focus will be on finding examples from the past that are actually credible, that different stakeholders can agree on. And I'm just going to scroll through this as I talk so you get a sense of some of the project. In order to start changing the way that this intergovernmental space works. So we have a process goal in mind as well as an outcome goal. The process goal is just to start modeling the incorporation of diverse voices into our process so that people stop assuming that we can just talk amongst ourselves. So that's certainly our own internal goal. But the external goal is that it allows people who aren't normally in these intergovernmental spaces to participate in the dialogue and actually have a pathway potentially straight to ministers. Because obviously at the end of the day, this IGWIG group only does what ministers ask us to do. So the final concluding message, because I have about 10 seconds, is that I would encourage each of you to actually write to the Ministers of Natural Resources, either at the provincial level or the federal level, and ask to come to the next Mines Ministers Conference, which is in September 2010. Now, the focus of this conference is going to be on competitiveness because we're coming out of the recession, and of course that's been everybody's bandwagon. But what we did in the report, which I encourage you to read, is we linked social license to competitiveness, and we linked performance improvements to social license. So now you have a pathway, a narrative pathway that says if you improve your performance, you enhance competitiveness. And if you improve performance, you get a chance to have this kind of conversation, which we don't have often enough. So I'll stop there. Thank you. Okay. How was it for time?
Compliance from the panel that we actually have some time left in this session. So we can open it up to questions from the panel members. If there were points that you were just dying to get to and I cut you off, this might be your chance also to jump in with those. Questions to the panel members? Professor Simon?
I'd like to just ask a question of Nadine, because this idea of opening the dialogue and including different stakeholders in this dialogue, I guess I'm slightly surprised because we did invite the province to come today and speak about Bill 173 and what they hope to attain with that. And they said they couldn't come because of the cases that we had framed in terms of the framing document for this workshop, that they were still ongoing litigation, that they couldn't send somebody to just talk about the bill, which in some ways is understandable, but in other ways they are the government and we would expect them to kind of engage on this issue and in the public meeting. And so I wondered if you, not that this is obviously the province and the federal government, but like how do we move forward from that type of thing? Because they're worried about a legal issue, guess, discussing something legal that's going to put them in a bad position, but.
Yeah. Well, that's an awkward question.
Okay, sorry.
No, that's okay. Maybe what I'll do is I got the same response when we invited Mining Watch to join our multi-stakeholder committee, because there is ongoing litigation. And for whatever reason, perhaps it's the particular leadership that we have. And I will say that our Assistant Deputy Minister, Stephen Lucas, is actually very committed to multi-stakeholder processes. Made the decision that it's a closed group, it's a sort of Chatham House rules type environment, and he felt that was sufficient to mitigate any of those legal risks, and to start demonstrating good faith. And I think it's perhaps one of those generational changes that's going to be coming. But when it comes to legal issues, it's really hard for me to.
No, I know,
comment.
and obviously there's no Chatham House rules here because they're going to be on video.
Yeah, but
it's
yeah. I will say that Natural Resources Canada did go through an internal organizational review process of how it operates, and in our new strategic framework, embedded in that language is a commitment to stakeholder engagement, and so that's the kind of language that you could refer to when you write to our minister and say, in the interest of operationalizing your new departmental commitment to stakeholder engagement, it would be great to have opportunities for dialogue about these XYZ issues. And so that's what motivates us to engage despite other challenges. So I'll just leave it at that.
okay. Thank you. I appreciate you
Okay.
taking that difficult question. This is maybe more a comment than a question, although perhaps also a question if you can answer it. In terms of Mines Ministers, you started out by asking, has anyone ever been to Mines Ministers? And I don't know if, I think there was only one hand that went up, and that's Mining Watch. And we really pushed our way in, but it was not an open door. It's not easy for people to go to Mines Ministers, and it's even harder to actually present there. So, you know, we were able to persuade people that we should be allowed in 1 year after a number of years of asking and being told no. And when we finally did get in, you know, that was fine. But then when we said, look, we'd actually like to present, so we'd actually like to have a voice here, that was another hurdle. So it's not a particularly open forum. That may have changed recently, but it hasn't been in the past.
So one quick maybe comment is that on the flip side, one of the benefits of Mines Ministers not being as accessible is ministers have felt in the past that they were being pressured by lobbyists for industry at Mines Ministers. And so I do believe that one of the reasons that the door narrowed was because they felt as ministers, the industry has lots of opportunities to give them their positions, but they don't have time as ministers to talk privately. And so I know that that actually was one factor that motivated the shrinking of the doorway. Now, one of the consequences is that other voices also get shrunk. And I do think they're looking at it right now for next year. They're reimagining what EMMC 2010 looks like. So if you have ideas on the kinds of conversational spaces that address the ministerial concern to not be lobbied all the time, but also create the opportunity for real dialogue, those ideas would be welcome in the next 4 weeks if you have time. So, and I'm happy to take some of those ideas and funnel them in.
Well, I've got one of those for you. Comment and I guess 2 questions. Comment is that when it comes to mining issues, the federal government tends to frame its role as being a coordinator amongst provincial and territorial governments, but it really doesn't have much to do with the federal government. And so I give kind of 2 questions about that. One is that of course, federal ministers in other predominantly provincial sectors from time to time have opened the dialogue from federal, provincial, territorial ministers, FPTs, into FDTAs, namely federal, provincial, territorial ministers and Aboriginal leaders. And of course, the social union that was all government signed parties created such a dialogue, and so you've had Aboriginal leaders involved in that even outside of constitutional negotiations. And it seems to me that particularly on mining issues, given the litigation framework that's occurred in various parts of the country, that if mining ministers are interested in increasing credibility and opening up dialogue, an ideal way of doing that is to follow that pattern where we do have precedents in other sectors for direct participation of Aboriginal leaders in those, not only in the annual Mine Ministers Conference, but also in the Intergovernmental Senior Officials process. So it's kind of a suggestion of a way to do that, or a question as to why not the feds haven't done it. Second part of it really is within federal jurisdiction itself. And again, the federal mining legislation within the jurisdiction is hardly something that one could hold out as being a best practice. And so I'm curious if, if NRCan likely to come to grips with those issues within the federal domain overall. And of course, one of the areas that is perhaps the worst regulated in Canada is in fact Indian reserve lands. And so I'm curious, what's the federal government doing in terms of its own house?
You can see why Ontario didn't show up.
I'm not putting you on the spot. It's not federal government. You have to represent the entire universe. No, it's a nice practical question.
I'm happy to be here. Okay. The first comment about the suggestion, it's a good one, and I think one of the particular dynamics that the federal government faces in Canada around its role in what is primarily provincial jurisdiction is we're one of the few areas that actually has a formal cabinet policy that actually spells out what our role is. A lot of other, like HRSCC doesn't have that. Human Resources and Skills Development doesn't have that. And it's the 1992 Mineral Policy of Canada. And I would encourage folks to read it. It's on the NRCan website, and I'll certainly dig it up and send it around afterwards. But what was interesting was we did have a lot of, we were actually hip deep in mining until program review with Martin challenging the deficit and so on in the early 90s. And we actually had agreements with every single jurisdiction, provincial jurisdiction, where the federal government flowed money down. And that gave us the ability, just like the health and social transfers, to talk about mineral stewardship and our expectations and our hopes and so on. And that money got completely cut as part of the deficit slaying exercise. And with the reduction of that funding, we lost. We traded off, essentially. We said, we'll stop bugging you, but we won't give you any money anymore. And now our jurisdiction is very, very narrow, and it's been a long road to try to now reimagine what that role looks like. And I think now is the time to have that conversation with the federal minister does have a mandate for sustainable development of natural resources. Now what that looks like and how it plays out in that intergovernmental space is still being imagined. And I think there's a growing desire to turn the IGWIG and MMC process into a dynamic environment of continuous reflection and continuous improvement. And that's what the social license review is really about. And that's what our department is really passionate about. So I'll leave it that point there. But if other people have suggestions about what that intergovernmental space could look like, this is the right time to share them. On federal jurisdiction in our own backyard, I mean, Indian and Northern Affairs Canada is does have jurisdiction for the stewardship of resources in the north. And I will say, I will have to deflect that and say I don't know enough about that because I haven't had the time to learn. So I'll have to. But Rob Johnstone, my colleague at Natural Resources, is going to be more than happy to answer those questions, as well as Doug Padgett from INAC. So I'll just refer to them, and their names are now on record. So.
Another, maybe a comment and input to the process that you talked about, receiving suggestions about how the government can engage and can receive input and engage with other actors. It seems like I have the perception that there's more interest in doing that when it's on the government's terms. So you know that at the beginning of November, civil society and industry came together and organized an event to discuss these issues, and that the government withdrew its participation from that event. And so my suggestion or my feedback to you would be that it doesn't have to be just the fora that are convened by government. There was a very thoughtful, interesting conversation that happened that day, and unfortunately, government wasn't part of it. So we're also convening those spaces, and it's very important that government's there.
I agree. I was one of the people that had to leave that space. So, yeah, no, I hear you.
I have a question for Maureen and a question for Will. Maureen, can you talk a little bit about the relationship between the Mining Act and the Environmental Bill of Rights? Because certainly from a human rights perspective, when we're thinking about human rights, the Environmental Bill of Rights has this very important overarching role in Ontario. And Will, again circling back to human rights, I was wondering if you could talk at all about the relationship between the statutory human right to environment that we have in Quebec and the mining regime.
Yeah. That was one of, I didn't get to all the details of the report, but one of the recommendations in the report is, in terms of the transparency issue, is stronger ties between the Environmental Bill of Rights and the Mining Act, and ensuring that decisions made under the Mining Act are on the Environmental Bill of Rights, and there is an opportunity, there's public notice and an opportunity to comment, because it's not that strong a link right now. Most of the mining process happens and is well underway before you might be at the stage of actually beginning to mine and maybe needing a certificate of approval for a sewage system or something. And at that point, finally, something appears on the Environmental Bill of Rights registry and you have 30 days to comment on it. But you know, the cow's out of the barn, or whatever that expression is, at that point, it's going to have a pretty minor impact. The comments will have a very minor impact on the impact of the mining at that point. So we were strongly recommending much earlier opportunities. Now, with this new permitting process that's been introduced into the Act, which is all going to be set out in the regulations. Hopefully at the regulation-making stage, we'll be able to press the government to have these exploration plans and exploration permits subject to the EBR. But even then, you know, they're already a ways down the road. It would be, you know, better, the earlier the better in terms of public input having any meaning in this process. But hopefully, the development of the regulations, there'll be some opportunities to make stronger ties. Now, the environmental assessment part will be interesting, because if EA for mining is going to be in the regulations, there will be better opportunities to have an EBR tie-in there. Currently, the Environmental Assessment Act is pretty much exempt from the Environmental Bill of Rights, because the government considered them to be kind of duplicating processes. So that's another whole battle in Ontario, but if EA is in the regulations under the Mining Act, there may be more opportunities for public comment on mining EAs than there are right now on other types of EA. Oh yeah, sorry.
I could be fairly brief on the Bill of Rights question, or the, environmental rights in Quebec question, but just by way of background, people who don't know, in Quebec there are two statutes that provide Quebecers with right to a healthy environment. One is the Environmental Quality Act, and that's Section 19, and that provides for also, among other things, it provides for injunctive relief, which is of great interest. And then there's I think it's Section 46.1 of the Quebec Charter of Human Rights and Freedoms, which also provides an individual right to a healthy environment. The trick with these rights, though, is that they're only pursuant to existing environmental laws and regulations as on the books. So your right is limited to that which is already protected by the government. So to the extent that the mining industry is really not particularly affected by a whole bunch of core environmental statutory obligations, to wit, the environmental assessment procedures, certificate of authorization, or certificates of authorization under Section 22 of the Environmental Quality Act. They don't need a lot of these things. So when they don't have obligations to follow under those laws, they're also not going to be held accountable under.
So then you're stuck with essentially pollution infractions. If you have a mine that is, say, violating the Fisheries Act or Provincial Water Protection Statute, then you might be able to seek injunctive relief based on the statutory right.
That's right. And that's I mean, so that's an across the board weakness of the
Right.
of the right in Quebec. If I could take a quick opportunity to make a comment on Adim's presentation. In terms of improving the Mining Act's image, I think it's a great approach, because it really does focus on, you know, how are they perceived. And I think more and more they're perceived as bullies, and they don't see that. But that's how the rest. I mean, even in Hollywood movies, that's how they're being portrayed. And I mean, I think about a client that we're representing right now, a Quebec publishing house, Eco Société, and 3 of its academic authors, including Alain Deneau. And they're being sued both in Quebec by Barrick Gold and in Ontario by Banro for having published an academic book which wasn't primary research, which simply went to a variety of reputable sources, UN, WHO, New York Times, that kind of thing, and said this is the evidence that's been collected on their behavior in the Great Lakes region of Africa. Clearly, something is amiss here. Something's wrong. And you know, when you get a defamation suit, you know, a slap suit going, you know, that just contributes to the image. So I think that they need to do a bit of soul searching as well. And I don't know what the federal government can contribute to that kind of process. Is as long as voices of you know, voices who are out there, you know, critiquing the industry are being slammed, you know, we're going to be in for a divisive battle. So.
Oh, I just
I mean, if you wish, it's more of a comment.
I just wondered if I wanted to ask you, Maureen, if you could expand on you didn't get a chance to talk about the exemption for the far north through land use planning that's inconsistent with mining, and how that hasn't happened in southern Ontario and in the near north. And so what it means is that all of us who live in southern Ontario are now not going to have our property staked. We own our land in fee simple, right?
Right.
And if you live in the near north and you own your land in fee simple, you can request that for it to be removed.
That's right.
At the minister's discretion.
That's
but
right.
if you're an Aboriginal person and it happens on your traditional lands, you don't have really anything that you can do except rely on your rights consultation. So I just wondered if you could expand on that a bit, and Will, if there's anything equivalently to that.
Yeah, I mean, the far north there's more at play, because the provincial government has also introduced a separate bill on far north land use planning. And this is all part of a commitment to protect some of the boreal forest in Ontario. So I didn't mention that, but that plays into what's in the Mining Act. Now, I don't believe I haven't been following it as closely, but I don't think the Far North Act has been passed, the Far North Land Use Planning Act. But they were introduced, relatively close together within a month or so. And there are links between the two statutes. And yes, Southern Ontario, that land's been withdrawn now, and you're right. In the near north, you can ask for that land to be withdrawn, but there will. For Aboriginal communities in the far north, there will be some opportunities around the land use planning. Aboriginal communities in Southern Ontario and the near north are in a very disadvantaged position relative to those in the far north, and it's an inequity. And we recommended that changes be made that would make for more of a level playing field, but those recommendations were not followed. So it's an outstanding concern, and I know that when the first reading Bill 173 was introduced in late April, I know there was a lot of concern and unhappiness on the part of some First Nations groups, and I'm sure that may be referred to later today. But I don't think the government really, well, I'm sure they understand, but for whatever reason, they've decided not to address this issue.
With respect to Quebec, it's a different situation up north with the James Bay Convention that was signed some years ago. The Cree are guaranteed environmental assessments on mining projects advanced. So there's, in fact, there's a real distinction between the treatment that's guaranteed to those who live who are covered under the James Bay Agreement and those to the south. And so that's actually a distinction that we've sort of raised, sort of saying, yeah, they've got it right up north, and down here there's some serious, down in the south there's some serious problems. But Quebec has, and I should defer to Sophie Thériault's knowledge on this issue, but my understanding is there's only three First Nations in Quebec that have comprehensive land claims deals: the Innu, the Cree, and the Naskapis. Yeah. So there are 8 other First Nations that remain uncovered, and there's that then for those areas that don't have a specific environmental assessment regime or specific consultation, accommodation, consent regimes, the problems are very, very much the same as the rest of Quebec.
So you mentioned that the next mining ministers conference is about competitiveness, and I was wondering how is it framed? How does it play out? Is it discussed as dynamics between provinces, or is it the Canadian mining industry's competitiveness at an international level, and what kind of issues are discussed in this context?
Okay. The way competitiveness is framed in mines ministers is domestic. So they look at that overlap between the social and economic side. So their focus will be mining investment in Canada, mining communities in Canada, employment. So for them, the discussion revolves around how can they ensure that the industry continues to generate jobs and opportunities for Canadians. So that's kind of their focus. And so the way it plays out in terms of discussions is they usually have a variety of panel discussions with people from banks and mining companies and financial analysts talking about the health of the financial health of the industry. And then that will play into sessions where they generate possible solutions. So they might say, we should extend the mineral exploration tax credit for another year. They might say we should renew our commitment to the Targeted Geoscience Initiative, which supports exploration near existing mining communities to extend the reserve life so that a mining community doesn't face the mine closing and then having to deal with the social dislocation that results. They might look at the regulatory improvement process. So they might say, okay, it takes 6 years to get a mine permitted right now, and we don't have a lot of projects in the pipeline, so we have to improve that federal provincial cooperation so that projects get online faster. So that's the kind of discussion that they have. I know that 2 of the focuses will be the Green Mining Initiative is one where, so Natural Resources Canada is interested in using the competitiveness discourse to also talk about the improvements. So there's, so our department has launched a Green Mining Initiative with $8 million allocated to how new mining technologies can both enhance competitiveness, let's say by reducing energy use, but also improve environmental performance. So that would be an example of how you can piggyback onto a competitiveness discourse to get other things that Canadians care about on the table. So that's a very rough. Does that answer your question?
And is there a dynamic between provinces?
A dynamic? Yeah. Like a competition?
Yeah, as to that could affect regulation, for example, as some province could want to reduce its regulation framework in order to attract more investment.
Yeah. So this is the race to the bottom discussion?
Or yeah. Is there a discussion between provinces so that the regulation can be effective in all provinces, so that there is not this pressure produced by competition between provinces?
That's a good question. I've actually never been to a mines minister myself. I'm too low on the totem pole, but I don't know to what extent that plays into their discussions. So I don't know, Catherine, if you heard any of that, but
Mine Watch has been. I haven't been.
Okay.
Normally
You do international, yeah. Yeah, no, I would imagine that it's maybe a subtext, so perhaps the jurisdictions are looking at each other to sort of, for that exact dynamic, but to my knowledge, it would never consciously come out as a discussion of how do we harmonize across provinces to make sure that there's a floor. I I don't know that that has come up, but I don't know that it has not come up. But it's a good question. I will ask, and I'll get back to you. Okay.
All right, we're at exactly 10:15, so we are outperforming my expectations so far, both time and content. We will now have 15 minutes just to get some refreshments, and we'll come back with the next panel at 10:30.